This audio recording covers the most important parts of two HOA documents. The first is the HOA bylaws, which are the rules for how the board of directors run the HOA meetings and finance it. The bylaws do not contain any rules for how owners need to keep their property. The second document is the declaration of covenants, conditions, and restrictions. Only Article 6 is read, which is all the rules for homeowner. The bylaws are the rules for the board of directors. Article 3, meetings of members. Section 3.1, annual meetings. The first annual meeting of the members shall be held on the first Tuesday in October of 1996, or on such other date as determined by a vote of the board of directors. And each subsequent regular annual meeting of the members shall be held on the first Tuesday in October each year thereafter, at the hour of 7 o'clock p.m. If the day for the annual meeting of the members is a legal holiday, the meeting will be held at the same hour on the first day following, which is not a legal holiday. Section 3, special meetings. Special meetings of the members may be called at any time by the president or by the board of directors, or upon written request of the members who are entitled to vote 1/4 of all of the votes appurtenant to the lots. Section 303, place of meetings. All meetings of the members shall be held at such place within Mecklenburg County, North Carolina, as shall be determined by the board of directors of the association. Section 3.4, notice of meetings. Written notice of each meeting of the members shall be given by, or at the direction of, the secretary or person authorized to call the meeting, by mailing a copy of such notice, postage prepaid, not less than 30 days, nor more than 60 days before the date of such meeting to each member entitled to vote thereat. Addressed to the member's address last appearing on the books of the association, or supplied by such member to the association for the purpose of notice. Such notice shall specify the place, day, and hour of the meeting, and, in the case of a special meeting, the purpose of the meeting. Section 305. Classes of lots and voting rights. This section no longer applies to our HOA, so will be skipped. Section 3. Quorum. The presence at the meeting of members entitled to cast, or of proxies entitled to cast, 1/3 of the votes appurtenant to the lots shall constitute a quorum for any action except as otherwise provided in the Articles of Incorporation, the Declaration, or these bylaws. If, however, such quorum shall not be present or represented at any meeting, subsequent meetings may be called, subject to the same notice requirement, until the required quorum is present. No such subsequent meeting shall be held more than 60 days following the preceding meeting. Section 307. Proxies. At all meetings of members, each member may vote in person or by proxy. All proxies shall be in writing and filed with the secretary. Every proxy shall be revocable and shall automatically cease upon conveyance by the member of his lot. Section 308. Action by members. Except as provided otherwise in the Articles of Incorporation, the Declaration, or these bylaws, any act or decision approved by a vote of no less than 2/3 of all votes present at a duly held meeting of the members at which a quorum is present shall be regarded as the act of the members. Section 309, waiver of notice. Any member may, at any time, waive notice of any meeting of the members in writing, and such waiver shall be deemed equivalent to the giving of such notice. Attendance by a member at any meeting of the members shall constitute a waiver of notice by him of the time and place thereof, except where a member attends a meeting for the express purpose of objecting to the transaction of any business, because the meeting was not lawfully called. If all the members are present at any meeting of the members, or are present at a meeting of such members, no notice shall be required, and any business may be transacted at such meeting. Section 3.10. Informal action by members. Any action which may be taken at a meeting of the members may be taken without a meeting if a consent in writing setting forth the action so taken shall be signed by all of the persons who would be entitled to vote upon such action at a meeting, and filed with the Secretary of the Association to be kept in the Association's minutes book. Article 4, Board of Directors. Section 4.1. Number. The business and affairs of the association shall initially be managed by a board of 3 directors who need not be members of the association. Section 4.2. Initial directors. This section will be skipped. Section 4.3. Nomination for election to the board of directors shall be made from the floor at the first meeting of the members. After the first election of directors, nomination for election to the board of directors shall be made by a nominating committee. Nominations may also be made from the floor at the annual meeting. Section 4.4. Election. Except as provided in Section 4.6. Directors shall be elected at the annual meeting of the members by written ballot. At such election, the members or their proxies may cast, in respect to each vacancy, as many votes as they are entitled to exercise under the provisions of the Declaration. The persons receiving the largest number of votes shall be elected. Cumulative voting is not permitted. Section 4.5. Term of office. Each director shall hold office for the short term for which he was elected, or until his death, resignation, retirement, removal, disqualification, or until his successor is elected and qualified. At the first annual meeting of the members shall elect 3 directors, one of which for a term of 3 years, another for a term of 2 years, and the third for a term of 1 year. Following the first annual election, all directors shall be elected for 3-year terms to succeed any director whose term then expires. Nothing contained herein shall be construed to prevent the election of a director to succeed himself. Section 4.6. Removal. Any director may be removed from the board with or without cause by a majority vote of the members of the association. In the event of death, resignation, or removal of a director, his successor shall be selected by the remaining members of the board and shall serve for the unexpired term of his predecessor. The members may elect a director at any time to fill any vacancy not filled by the directors. Article 5, Meeting of Directors. Section 5, Regular Meetings. Meetings of the Board of Directors shall be held on a regular basis as often as the board sees fit, but no less often than annually, on such days and at such place and hour as may be fixed from time to time by resolution of the board. Should said meeting fall upon a legal holiday, then that meeting shall be held at the same time on the next day, which is not a legal holiday. Section Special Meetings. Special meetings of the Board of Directors shall be held when called by the President of the Association or by any 2 directors, after not less than 3 days' notice to each director. Section 5.3. Quorum. A majority of the number of directors shall constitute a quorum for the transaction of business. Every act or decision done or made by a majority of the directors present at a duly held meeting at which a quorum is present shall be regarded as the act of the board. Section 5.4. Informal action by directors. Action taken by a majority of the directors without a meeting is nevertheless board action if written consent to the action in question is signed by all of the directors and filed with the minutes of the proceedings of the board, whether done before or after the action so taken. Section 5. Chairman. A chairman of the board of directors shall be elected by the directors and shall preside over all board meetings until the president of the association is elected. Thereafter, the president shall serve as chairman. In the event there is a vacancy in the office of the presidency, a chairman shall be elected by the board of directors and serve until a new president is elected. Section 5.6. Liability of the board. The members of the board of directors shall not be liable to the owners for any mistake of judgment, negligence, or otherwise except for their own individual willful misconduct or bad faith. The owners shall indemnify and hold harmless each of the members of the board against all contractual liability to others arising out of contracts made by the board on behalf of the association, unless any such contract shall have been made in bad faith or contrary to the provisions of the declaration or these bylaws. It is intended that the members of the board of directors shall have no personal liability with respect to any contract made by them on behalf of the association, except to the extent that they are owner at Article 6, Powers and Duties, Section 6.1, Powers. The Board of Directors shall have power to a. Adopt and publish rules and regulations governing the use of the common area and facilities, and the personal conduct of the members, their guests thereon, and to establish penalties for the infraction thereof. B. Suspend the voting rights and right to use of the recreational facilities of a member, any period in which such member shall be in default in the payment of any assessment levied by the association. Such rights may also be suspended after notice and hearing, for a period not to exceed 60 days for infraction of published rules and regulations. C. Exercise for the association all powers, duties, and authority vested in or delegated to this association and not reserved to the membership by other provisions of these bylaws. The Articles of Incorporation or the Declaration. D. Declare the office of a member of the Board of Directors to be vacant in the event such member shall be absent from 3 consecutive regular meetings of the Board of Directors. E. Employ a manager, an independent contractor, or such other employees as they deem necessary, and prescribe their duties. F. Employ attorneys to represent the association when deemed necessary. G. Grant easements for the installation and maintenance of sewer or water lines and other utilities or drainage facilities upon, over, under, and across the common area without the assent of the membership when such easements are requisite for the convenient use and enjoyment of the property. H. Appoint and remove, at pleasure, all officers, agents, and employees of the association. Prescribe their duties, fix their compensation, and require of them such security or fidelity bond as it may deem expedient. I. Do anything necessary or desirable, including, but not limited to, establishing any rules or regulations which the association deems necessary to carry out the purposes of the association as set forth herein or as permitted by law. J. To enforce the provisions of the declaration and any additional or supplementary declaration and any rules or regulations made hereunder or thereunder, and to enjoin and or, at its discretion, seek damages or other relief for violation of such provisions or rules. K. To levy assessments, as more particularly set forth in the declaration. Section 6.2. Duties. It shall be the duty of the Board of Directors to cause to be kept a complete record of all its acts and corporate affairs and to present a statement thereof to the members at the annual meeting of the members, or at any special meeting when such statement is requested in writing by members entitled to at least 1/3 of the vote appurtenant to the lots B. Supervise all officers, agents, and employees of the association, and to see that their duties are properly performed. C. As more fully provided in the declaration. C1. Fix the amount of the assessments as more particularly described. D. In the declaration. C2. Send written notice of each assessment to every owner subject thereto before its due date. And C3. Foreclose the lien against any property for which assessments are not paid within 30 days after due date, or to bring an action at law against the owner personally obligated to pay the same. D. Issue, or to cause an appropriate officer to issue, upon demand by any person, a certificate setting forth whether or not any assessment has been paid. A reasonable charge may be made by the board for the issuance of these certificates. If a certificate states an assessment has been paid, such certificate shall be conclusive evidence of such payment. E. Procure and maintain adequate liability insurance covering the association and the directors and officers thereof, and adequate hazard insurance on the property owned by the association. F. Cause all officers or employees having fiscal responsibilities to be bonded as it may deem appropriate. And G. Cause the common areas to be maintained. Article 7. Officers and their duties. Section 701. Officers. The officers of the association shall be a president and vice president, who shall at all times be members of the board of directors, a secretary, and a treasurer, and such other officers as the board may from time to time by resolution create. Section 702. Election of officers. The election of officers shall take place at the first meeting of the board of directors following each annual meeting of the member. Section 7.3. Term. Each officer of the association shall be elected annually by the board, and each shall hold office for 1 year or until his death, resignation, retirement, removal, disqualification, or his successor is elected and qualifies. Section 704. Special appointments. The board may elect such other officers as the affairs of the association may require, each of whom shall hold office for such period, have such authority, and perform such duties as the board may, from time to time, determine. Section 705. Resignation and removal. Any officer may be removed from office with or without cause by the board. Any officer may resign at any time by giving written notice to the board, the president, or the secretary. Such resignation shall take effect on the date of receipt of such notice or at any later time specified therein, and unless otherwise specified therein, the acceptance of such resignation shall not be necessary to make it effective. Section 7. Vacancies. A vacancy in any office may be filled by appointment by the board. The officer appointed to such vacancy shall serve for the remainder of the term of the officer he replaces. Section 7. Multiple offices. The offices of secretary and treasurer may be held by the same person. No person shall simultaneously hold more than one of any of the other offices, except in the case of special offices created pursuant to Section 704. Section 7.8. Compensation. No officer shall receive any compensation from the association for acting as such. Section 7.9. Duties. The duties of the officers are as follows. President A. The president shall be the principal executive officer of the association and subject to the control of the board, shall supervise and control the management of the association. The president shall preside at all meetings of the board of directors, shall see that orders and resolutions of the board are carried out, shall sign all leases, mortgages, deeds, and other written instruments, and shall co-sign all checks and promissory notes. Vice President B. The vice president shall act in the place, instead of the president, in the event of his absence, inability, or refusal to act, and shall exercise and discharge such other duties as may be required of him by the board. Secretary C. The secretary shall record the votes and keep the minutes of all meetings and proceedings of the board and of the members, shall keep the corporate seal of the association and affix it on all papers requiring said seal, shall serve notice of meetings of the board and of the members, shall keep appropriate current records showing the members of the association together with their addresses, and shall perform such other duties as required by the board. Treasurer D. The treasurer shall receive and deposit in appropriate bank accounts all monies of the association, and shall disperse such funds as directed by resolution of the board of directors, shall sign all checks and promissory notes of the association, shall keep proper books of account, shall cause an annual audit of the association books to be made by a public accountant at the completion of each fiscal year, and shall prepare an annual budget and a statement of income and expenditures to be presented to the membership at its regular annual meeting, and deliver a copy of each to the member. Article 8. Committees is skipped. Article 9. Books and records. The books, records, and papers of the association shall at all times, during reasonable business hours, be subject to inspection by any member. The declaration, the articles of incorporation, and the bylaws of the association shall be available for inspection by any member at the principal office of the association, where copies may be purchased at reasonable cost. Article 10. Assessments. As more fully provided in the declaration, each member is obligated to pay to the association annual assessments and special assessments as defined in the declaration. Any assessments which are not paid when due shall be delinquent. If an assessment is not paid by its due date as set forth in the declaration, the assessment shall bear interest from such due date at the rate of 18% per annum, or the highest rate then permitted by law, whichever is less, plus such late charge as may be established by the board, and the association may bring an action at law against the member personally obligated to pay the same. The late charges, costs of collection, and reasonable attorney's fees related to any such action shall be added to the amount of such assessment, all in accordance with the provisions of the declaration. No member may waive or otherwise escape liability for the assessments provided for herein by non-use of the property. The next document is the HOA Declaration. Article 6, Use Restrictions. 6.1, Use of Common Areas. No planting or gardening by individual owners shall be done upon any common area, except for the right of easement of enjoyment in and to the common areas herein given to each owner. Owners are hereby prohibited and restricted from using any of the common area except as may be allowed and prescribed by the association's board of directors or as expressly provided for herein. It is developer's intent that this paragraph inure to the mutual benefit of all owners within the properties, and each owner shall have a non-exclusive easement right to use and enjoy the common areas which shall be appurtenant to and shall pass with the title to his lot, subject to the following: A, the right of the association to promulgate and enforce reasonable regulations governing the use of the common areas to ensure the availability of the right to use the common area to the owners and the safety of all owners on the common areas. B, the right of the association to suspend the voting rights of an owner in the association and the right of the association to suspend the right to use certain or all of the common areas by an owner for any period during which any assessment against his lot remains unpaid, and for a period not to exceed 60 days for any infraction of its published rules and regulations. C, the right of the developer or the association to grant utility, drainage, or other easements across the common areas. And D, the right of the developer or the association to permit use of any recreational facility situated on the common area by persons other than owners, their families, lessees, and guests upon payment of use fees established by the developer or the association. Use of lots. Each lot now or hereafter subjected to this declaration are subjected to the following restrictions as to the use thereof running with said property by whomsoever owned. A residential lots only. All lots in the tract shall be known and described as residential lots. No structure shall be erected, altered, placed, or permitted to remain on any lot other than a single-family dwelling not to exceed 2 1/2 stories in height, excluding basement and one other accessory structure customarily incidental to the use of the lot. All accessory structures shall be constructed in harmony with the dwelling house. B, setbacks. No building shall be located nearer to the front property line or any side street line than the building setback line as shown on the recorded map. No building shall be located nearer any side lot than the applicable zoning ordinance shall allow. In the event of the unintentional violation of any minimum setback requirements herein set forth, developer, for itself and for its successors and assigns, reserves the right, BR, and with the mutual consent of the owner of the lot in question, to change the restrictions set forth in this instrument, provided, however, that such changes shall not exceed 10% of the marginal requirements of such restriction. C, minimum square footage. Skipped delimitation of subdivision of lot. No lot shall be subdivided so as to increase the total number of lots shown on said recorded plat. E, driveway. Any driveway constructed or used in or on any lot in the subdivision shall have either an asphalt, brick, or concrete surface which shall be kept and maintained in good condition and repair. F, maintenance. Exterior maintenance, upkeep, and repair to the yard, fence, walkways, shrubbery, dwelling, and other improvements on each lot shall be the sole responsibility and expense of the owner of the lot. The owner of each lot shall maintain his lot or lots in a neat and clean condition, free of all trash, debris, weeds, and vines. The yard, grounds, shrubbery, and trees shall be maintained in a neat and trim condition at all times. Nuisances. No obnoxious or offensive trade or activity shall be carried on or upon any lot, nor shall anything be done thereof which may be or become any annoyance or nuisances to the neighborhood. H, other structures. No trailer, basement, tent, shack, garage, barn, or other outbuilding erected on the tract shall at any time be used as a residence temporarily or permanently, nor shall any structure of a temporary character be used as a residence. No above-ground swimming pool shall be permitted on any lot. No accessory structure shall be moved onto any lot unless it shall conform to and be in harmony with the existing structures in the tract as to design and color. No metal buildings shall be allowed to remain on any lot, and all accessory structures must be situated on a permanent foundation. Nothing contained herein shall prevent a construction trailer or sales trailer from being located temporarily on a lot during the construction of improvements within the subdivision. I, Utility and drainage easements. A perpetual easement is reserved over the rear 10 feet of each lot for utility installation and maintenance, and public and/or as shown on the recorded map. A perpetual easement is reserved over the side 5 feet of each lot line for utility installation and/or as shown on the recorded map. J sign. No sign of any kind shall be displayed to the public view on any lot except one sign of not more than 5 square feet advertising the property for sale or rent, or a sign used by a builder or developer to advertise the property during the construction and sales period. Developer shall have the right to place permanent signs for Southbridge Forest within the development. K. Animals and pets. No animals, livestock, or poultry of any kind shall be raised, bred, pastured, or maintained on any lot, except household pets which may be kept thereon for the sole pleasure and use of the occupants, but not for any commercial use or purpose, and no more than 3 pets over the age of 6 months, which stay primarily outside the residence, shall be permitted at any time. L. Rubbish and garbage. No lot shall be used or maintained as a dumping ground for rubbish. Trash, garbage, or waste shall not be kept except in sanitary containers. Fences and walls. No fence or wall shall be erected on a lot closer to the street right-of-way line than the front of the house. In the case of a corner lot, no fence or wall shall be erected within the side yard setback adjoining the road right-of-way except for split rail fences. Solid or privacy fences shall be erected entirely to the rear of the residence exclusive of decks and porches. Solid is defined for purposes of this declaration as fencing with more than 60% of any of its surface closed as viewed from a point on a line of sight perpendicular to the line of the fence. The following types of fences or walls shall not be erected on any lot. A. Chain link or other metal fencing is not permitted, except that 2-inch by 4-inch metal mesh may be used with split rail fencing to contain animals or children. B. Any fence or wall in excess of 6 feet in height. C. Any fence or wall located within the road right-of-way. D. Dog runs or animal cages. The location restrictions set forth above shall not pertain to any fencing erected within the common area or as part of the permanent entryways to Southbridge Forest. N. Clotheslines, garbage cans, etc. All garbage cans, lawnmowers, and similar equipment shall be kept in an enclosed structure or screened by adequate planting or fencing as to conceal same from the view of neighboring owners and streets. Clotheslines shall not be used nor permitted to be erected or placed on any lot. O. Radio and television antennas. No freestanding radio or television transmission or reception towers, antennas, dishes, or discs shall be erected on a lot. Only one radio and one television antenna attached to the residence, not exceeding 5 feet in height above the roof line of the residence, and only one dish attached to the house, not exceeding 2 feet in diameter, not visible from the street in front of the residence, shall be permitted. P. Commercial vehicles, buses, etc. No commercial vehicle in excess of 1 ton capacity or buses, including but not limited to school buses, shall be parked within the property shown on the above described recorded plats. In addition, no boats and trailers or campers shall be parked in front of the residence on any lot or within the front or side setback of any lot. Only one boat and trailer or one camper may be parked on any lot at any one time. No tagless or junk vehicles shall be parked on the street in front of the residence or on any lot unless in an enclosed garage. Q. Sightlines. No fence, wall, hedge, or shrub planting which obstructs sight lines at elevations between 2 and 6 feet above the roadway shall be placed or permitted to remain on any corner lot within the triangle area formed by the street property lines and a line connecting them at points 35 feet from the intersection of the street. Property lines extended or within any site easement shown on any recorded plat, or basketball goals within road right-of-way. No basketball goal shall be erected or allowed to remain within the right-of-way of any street located within the submitted property. S. Covenants independent of one another. Invalidation of any one of these covenants by judgment or court order shall in no way affect any of the other provisions which shall remain in full force and effect. T. Limitations. It is distinctly understood and agreed that nothing herein contained shall be taken and construed as imposing any conditions or restrictions upon any land not specifically covered by these restrictions. Architectural control. After completion of the construction of the principal residence located on any lot, no siding, fence, wall, or other structure shall be commenced or maintained upon the properties, nor shall any exterior addition to or change or alteration therein be made, including the erection of antennas, aerials, awnings, the replacement of reflective or other material in the windows of a house or other exterior attachment, until the plans and specifications showing the nature, kind, shape, heights, materials, and locations of the same shall have been submitted to and approved in writing as to the harmony of external design and location in relation to surrounding structures and topography by an art committee composed of 3 or more representatives appointed by developer or by the board of directors, once developer assigns to it the right of appointment hereunder. In the event said committee fails to approve or disapprove such design and location within 30 days after said plans and specifications have been submitted to it, approval will not be required, and this paragraph 6.3 will be deemed to have been fully complied with. The ARC committee shall have the right to charge a reasonable fee for receiving such application in an amount not to exceed $25. The ARC committee shall not approve any alterations, decorations, or modifications which would jeopardize or impair the soundness, safety, or appearance of any lot. Refusal or approval of plans, specifications, builder, or location may be based upon any grounds, including purely aesthetic consideration, which in the sole and uncontrolled discretion of the ARC committee shall be deemed sufficient, provided that nothing contained herein shall be construed to permit interference with the development of the properties by the developer in accordance with its general plan of development,